Hey, it's Tanya here with Tanya's 10 for the win. 10 essential legal tips every digital creator should know, right? It's a working title. All right, before we begin, I have to start with my legal disclaimer. So here goes. This is for informational and educational purposes only. Nothing in this talk or episode is intended as or should be construed as legal advice, nor does accessing, watching, listening to, or engaging with any of this content create an attorney-client relationship with Tanya Fisher, that's me, or Tanya Fisher IP Law. If you need legal advice, please consult an attorney in your jurisdiction and preferably one that is familiar with your business and your industry. All right, legal out of the way. Let's get down to it. Again, we're talking about the legal essentials, for digital content creators. That is you, right? And that's if you're doing audio, video, music, blogs, social media, okay? So as a digital content creator, it's so important to know what legal considerations and protections affect your business or your role as a content creator so that you can actually protect your work and ensure that your creative endeavors flourish without legal blocks or hiccups, right? So I want to share at least, 10 essential legal tips to help you out or that you should basically keep in mind, right? One of the absolute main legal considerations for digital content creators is copyright, okay? You must get familiar with and understand copyright law to protect your brand and also to make sure that you are not infringing on another's rights when you are creating and sharing your content, okay? So copyright law and copyright protects original creative works. And for digital content creators, again, those original works are often videos, podcasts, music, blogs, and graphics. Yes, I understand that that you automatically get a copyright in those as soon as they are fixed in a tangible form, and that copyright gives you exclusive rights to use, reproduce, or distribute your work, and actually to control how your work is used, reproduced, and distributed. That leads me to the importance of registering your copyright, okay? While your work is copywritten or you have a copyright in your original works upon creation, and when it's fixed in a tangible form, of course, registering your work, your creations with the Copyright Office really provides additional protection, and it's really necessary before you can file a lawsuit for infringement in the U.S. And remember, we're talking about U.S. Law today and definitely U.S. copyright. Now, I know you are asking about how to use someone else's works and content to enhance your content, or how to stop others from copying or stealing your content to quote unquote enhance their content, right? And these are legitimate concerns and considerations that must be addressed. And half the time, everyone wants to claim fair use, right? So first, let's talk about fair use is a defense to using someone's copyrighted content or their work without permission. So even thinking that way, it puts you on the defense of saying, hey, my actions need an excuse. And there's nothing wrong with that, okay? Fair use is fair use, but know that permission is number one, and it's what you should really be seeking. And then you want to recognize sort of what angle you're trying to come from when you're defending your own rights or when you're using someone else's copyright work, right? So is fair use a defense? Is that what you want? Should you just be getting permission? Because there are boundaries to fair use. It's for limited use, and a lot of times people are thinking, okay, well, I can use it. Maybe it's news reporting. Maybe it's a parody or something. But that's not always the case. There are many factors, and we'll talk about that another day. But get permission, get permission. Okay, next up, trademark. Trademark your brand. If your brand name or logo is really central to your digital services and products, consider registering a trademark, okay? This prevents others from using similar names or logos that can confuse your audience and community. You'll want to choose a name that's distinctive and, of course, does not infringe on the rights of others. So be sure to conduct a thorough search of the name and the name of the brand, the words, the logos, the design that you want to use. Do that online and with the USPTO, which is the U.S. Patent and Trademark Office. Okay, so it's a double search. And if you find that the name is in the clear, make sure to put everyone on notice that you are actually claiming the name, the mark, the design as a trademark. You're going to use the TM, right? And you're going to treat your name as a trademark. You're going to properly use your mark as a source of your services and goods, not as a sentence, not something crazy generic or whatever. So if it's Lemon Ladybug Media, you're not going to have LLM on everything unless you also intend to have that as a trademark. But you got to have Lemon Ladybug Media somewhere, right? You need to use that. You can't rarely use that. You got to put it on your marketing copy and on your sites, on your socials, okay? You have to use it all the time as a trademark. And all of these points we're going to discuss in greater detail in future episodes, but I really wanted to briefly touch on what I commonly see that diminishes a brand's protection, and especially that's something that can be avoided. So if you're using something as a trademark, use it as a trademark, okay? Think of it that way. We'll talk more later. All right. Contracts. You want to have contracts, and you want to have contracts that are robust and that have all the terms that you need to protect your brand and business. Contracts are a must. And you don't want to get contracts that you find on the internet, I'm sorry, or that your friend uses in their business. You want to have contracts that are tailored to your business and are beneficial to the particular transaction you need them for. So you might use it for something else, the contract you have, but you'll need a specific contract for your particular transaction. So when you think about hiring independent contractors like freelancers, people who are editing your podcast or your social media managers, when you're collaborating with other creators or licensing your work, you want to always use contracts. Contracts help to define expectations and responsibilities and clear agreements, prevent misunderstandings, and provide legal protection for all the parties involved, all right? So not only do you want to have contracts because they make you look professional, but they save you headaches and legal trouble and downfall. If someone is upset or scoffs at you because you're handing them a contract, then consider that a blessing in disguise, because for sure they will be the first person causing you the most problems, asking for refunds, not delivering on what they promise, and a whole host and bunch of other unnecessary BS that you will either be responsible for curing, paying for, or worse, okay? So if they don't want a contract, then you move on. Don't deal with them, okay? As much as possible. You need those contracts because you'll be miserable, broke, and burned out otherwise if you don't have that in place. And plus you're hanging with me now, so we're not going to be miserable, burnt out, and broke, right? That's not going to be your thing or your way of life and doing business. So off my soapbox and pep talk. All right. Next tip, protect your work. And that goes beyond registering your copyrights and trademarks and patents, etc., your intellectual property. You do want to make sure you have them registered. Um, think about it this way. We're all about being proactive, not reactive. One of the ways to additionally protect your creations and your innovations and your works and business is to implement measures to protect your digital content, okay? So that's in addition to registering. You put the terms of use on your website and in your contracts. You use watermarks possibly. You disable right-click functions on your website. You limit the amount of downloads or the shares. Maybe you use encryption or you use some other type of digital rights management software. It's called the DRM software if you ever hear about that. But you use those to deter unauthorized use or distribution of your work, right? And of course, yes, you do register those works with the correct offices, right? Copyright Office, USPTO. So, but that's in addition to just registering. You have to take those extra steps to protect yourself. And speaking of, while we're talking about monitoring and enforcing your rights, I want to emphasize that you should be enforcing your rights, right? You're monitoring them, but you should be enforcing your rights. If you just let people infringe or dilute your work and brand, you're just inviting others to do the same, and then your brand becomes worthless or damaged, and your work is out there all over the place, and it's going to be harder and more expensive for you to assert your rights. So you want to be on it, monitoring everything that's going on, looking out, and also enforcing your rights. Of course, you don't want to be overzealous, right? Sending out cease and desist letters when the content barely or remotely looks like your content or your brands, just because if you do that, you're going to really be setting yourself up for like a world of trouble, especially if you don't actually own the rights to what you're claiming someone is violating. Oh my goodness, there are just so many stories about that. But if you do feel or you know that someone is infringing upon your rights, your works, or they haven't credited you and giving you the proper attribution, let them know, okay? It's not crazy. Well, let's put it this way. If you know that they're doing all out craziness or something, they're doing it on purpose, okay, then you're going to really get out there and say something. But if you see your stuff somewhere, just tactfully ask someone or say, hey, I noticed that my work, whatever it is on your site or something, or was in your content, it was incorporated somewhere. I wasn't given credit or attribution, or I'd like you to take it down or remove it or the like. Just say, something like that. Be tactful about it. Be nice. Sometimes people really don't understand the law. They don't, or they think that it's on the internet and they can copy it or something, or, they could use it. It might even be a oversight or misunderstanding. And no, not giving any excuses. That is an excuse. But they may say like, yeah, hey, sorry, I didn't realize it. Or even if they did, they'll remove it right away or they'll credit you, okay? Whatever the case is, and you're requesting, just, kind of asking, hopefully they'll do that. Now, if they're saying they're not going to take it down and no, they're doing all of this and that, then yeah, you send them a nice cease and desist letter or DMCA takedown notice, etc. All right, you get your attorney involved, but ask first. Definitely ask. All right, the next thing, privacy and data protection laws. Okay, changing and they're expanding frequently. More and more states, they're implementing their own privacy and data protection laws and regulations. And you really have to make sure that you're in compliance as a digital content creator and or online business, right? If you collect any data from your audience and communities, you want to be aware of the privacy laws applicable in your jurisdiction and globally, like the GDPR in Europe. This applies to you because you're online. So yeah, you might be in California, but you're doing business worldwide. All right. So ensure your website and the like has a privacy policy that complies with these laws. All right. They're having too much fun in the streets. I know you hear that. So, but we're going to finish this video up. All right. Here's another one that is so overlooked. Observe advertising laws. It's your content that has endorsements or the like. Okay, they're really loud, so hold on. Okay, I'm back. They were really having a blast out there and some fun, but they had to go because the police were like, all right, too much going on here. Anyway, where were we at? Observing advertising laws. Okay, I remember now. If your content includes endorsements or promotional material, what you want to do is ensure transparency if you have sponsorships, affiliate links, or other forms of advertisement. And you want to stay compliant with advertising standards as well as consumer protection laws, okay? So be mindful of any guarantees. Be upfront about payment terms. Be upfront about what your customers, your clients, your community, what they're getting when they buy from you, when they engage with you, okay? Just avoid deceit at all costs, or know that it will truly cost you. And please, please, please make sure that you have disclaimers posted everywhere. And definitely you want to have them included in your contract. So you want them posted on your websites and the like, and you want them inside of your contract. So if you are not a lawyer, a physician, a financial advisor, etc., or you're not holding yourself out as one in the capacity of your business as a digital content creator or provider, then you need to state so. You need to make it known. You know, that disclaimer is a must. At the beginning, you heard me talk about how this is just educational information and it's not legal advice. You need to state that. All right, what's another one? Oh, make sure your business is set up properly for your current phase of business, so that it's okay now and that you're set up well in the future. And I know this seems like a given, but when you first start out, maybe you didn't have the same visions and ventures that you have today, okay? So you didn't have the business and legal essentials you need for the way that you do business today. Maybe you're still a sole proprietorship and you haven't registered your business with your state or whatever government municipality you need to. Maybe you're an LLC and you need to change your entity status and filings to an S Corp, right? Maybe your contracts are outdated and they don't cover all of your products and services and relationships, right? Not the ones that you have now. And maybe you don't even have the contracts that you need based on your business now. Maybe you don't have the licenses you need, right? Your insurance doesn't cover all of the things that you do, the transactions that you have. Your tech is outdated or no longer efficient for your operations, right? Your day-to-day, your workflow and your processes are outdated and inefficient, and they don't help you streamline your business, or you're wasting time. You're losing money, right? Or worse, you can't carry out your legal obligations. So what you need to do is, take a look at what's going on in your business. I want you to audit your business often to make sure that you stay efficient and legally compliant for each stage of your business, okay? So try to do that at least quarterly and at least yearly, okay? What's another thing? Clear the clips, clear the clips. All right, we've been talking about protecting your intellectual property and business interests, but of course you want to be mindful of not infringing on the rights of others and misusing and abusing their creations and innovations, right? I was like looking at my list. I was like, what is next? This is next. Clear the clips. If you're using audio-visual clips, sound bites, music, get permission to use those in your content, okay? Please get the licenses. Know what licenses you need for the particular type of content you are using and what you're incorporating it into, all right? So do you need a synchronization license, a sync license? Do you need a mechanical license? Where are you broadcasting at or from? Do you need a performance license then? And yeah, we talked about fair use earlier, right? You can't rely on fair use as your go-to, all right? The best practice, the best defense is getting permission to use the content from the owner of the content, all right? You may be able to use the content under fair use, but fair use, it's limited and it only allows limited use of works without permission, right? And there are numerous factors that need to be considered when you're claiming fair use as a defense for not getting permission for using something without permission. And you got to know, fair use, listen to me, it's not a blanket exemption from copyright infringement or being able to use someone else's work without permission. Fair use has its boundaries. It's actually called the fair use test. It's a balancing test used to determine if a particular use of another's content qualifies as fair. All right. So yes, I've gone on and on about fair use, so you know there'll probably be an episode or two with me on my fair use is not a hall pass or soapbox, whatever. It's coming. So let me just finish this up. I can start drafting out something about fair use. Oh, did you see that? My earring is out in a little bit. Okay, so last one. We're losing earrings. We got people driving their cars and bikes and spinning around in a crazy intersection in the street. So let's get this going. Stay updated with the laws and the changes in the law, okay? Especially the ones affecting you, right? These laws can change. They do change. So you want to make sure that you stay updated with what's going on. And always, of course, always consult an attorney to figure out what the new developments are and what you need to do in your business to make sure you are compliant. All right, so those are my 10 for the win. Make sure to hit that like button and everything. And of course, subscribe to my channel. Cups up. I'm wishing you optimal success. May you always be supported and celebrated and every bite of your cheesecake decadent, okay? If you want even more brand protection tips, then of course you're going to subscribe to my letter. But right now, what are we going to do? You are going to like this video and you're going to subscribe to the channel. All right, take care, be successful, protect your brand. And you know what? We'll chat soon.